Sorry, we're late, had a few technical difficulties. Welcome to today's webinar, What Service Providers Need to Know About GDPR, the ins and outs of the EU's new privacy law sponsored by Scott & Scott LLP, an intellectual property and technology law firm located in Southlake, Texas, recently recognized by Finance Monthly as the best technology law firm in the USA for the second year in a row. Your presenter, Robert Scott, has been practicing data security and privacy law for over a decade. Recently, he has been helping his clients who have international business interests prepare for the May 2018 effective date of GDPR. Today's presentation will be recorded, and you will receive a link in the next few days to access the recording. Tomorrow, you'll receive a short survey requesting feedback on today's webinar and your ideas for future topics. We appreciate hearing from you. Thank you. And now we're ready to start.
Thank you, Marcus. Good afternoon, good morning, good evening. We have a great audience, global audience today, and I'm very grateful to have you with me today. We've got a lot of ground to cover. I want to talk to you at a high level about all of the details involving GDPR. The slide deck will go into much more detail than I'll be able to cover during this call, but I do want to hit the highlights of the purpose of the GDPR, what its applicability is in terms of scope, what new privacy rights it creates and challenges that associated with those rights, what the enforcement landscape looks like, and then walk you through some practical roadmap and decision tree documents that we've developed for our clients to analyze the impact of the GDPR on their business and whether or not and to what extent they need to be making changes to what they've been doing in order to comply. And we'll talk a little bit about the types of advice that we're giving to our clients that are wrestling with the questions of GDPR. For those of you who don't know, the European General Data Protection Regulation, which we refer to as the acronym by GDPR, states that the processing of personal data is a fundamental right which needs to be protected. Essentially, that anybody in the EU whose data is going to be processed, regardless of where it's going to be processed, is subject to regulation, regardless of whether it's extraterritorial in nature or not. We'll go into that in some detail. The GDPR imposes specific obligations on processors, which are typically service providers, and controllers, which are typically those that control customer data. So in the context of IT services, this would be the end user client, and others with regard to their vendor relationships and the protection of personal data. GDPR requires companies to conduct appropriate due diligence on processors to have contracts containing specific provisions relating to data protection. This is where the transactional aspect of GDPR comes in, and if you're in a vendor management role, if you're in a sales role, this requirement is going to change the way IT services are contracted for going forward. IT services, hosting services, software services, cloud services, all have the potential to be impacted by GDPR's regulation. And if you are contracting in this area, there are very specific things that you need to add to your agreements. And we'll go into that in some greater detail. That for those of you who are in the USA, there is a lot of overlap between the types of requirements that GDPR is imposing and that which we have seen in other privacy and security regulations in the United States, most notably the HIPAA regulations and the GLBA regulations. So those of you who are familiar with US-based regulations will see some overlap, some familiarity in the concepts with GDPR, but GDPR certainly goes beyond that and lays down rules related to the protection of natural persons with regard to the processing of personal data and rules related to the free movement of personal data. A regulation protects fundamental rights and freedoms of natural persons, and in particular their right to protection of personal data. And the free movement of personal data within the Union shall neither be restricted nor prohibited for reasons connected with protection of natural persons with regard to the processing of personal data. You see that in each one of these bullets we're making references to the regulations. So if you want to do a deeper dive into some of these points, we're trying to provide you with some reference points. So what about scope? I think this is the one thing that most people are wrestling with, is what is the scope of the GDPR and how will it affect me? Personal data is processed in connection with goods or services to EU citizens, irrespective of payment. Then the GDPR applies. Whether you're in California, New York, Texas, Florida, Canada, it makes no difference. The only question on scope is whose personal data is being processed and for what reason. If you're dealing with EU citizens' data, then you have a high probability that you're going to be subject to the regulations in some capacity. And if EU data subjects' behavior is monitored, irrespective of whether or not you're processing personal data, if behavior is being monitored, this could be through the use of cookies or other behavior monitoring tools, then you have the potential of having GDPR apply to your business. So who does the GDPR apply to? Clearly, EU organizations. If you're established in the EU, then you definitely are subject to the GDPR. And for non-EU organizations, the GDPR applies to organizations that process personal data about people in the EU. And to this point, GDPR is an extraterritorial law, meaning it may affect U.S. companies and service providers of all types, including MSPs and cloud service providers, if they process personal data about EU people. The law will affect the MSP's business operations. Processing must be done in accordance with the GDPR guidelines. So regardless of where you are located, this law can reach to you by virtue of the fact that the customers, the people, the data that you could be processing or hosting or maintaining within your infrastructure. So this is a very wide sweeping regulation. And as Marcus pointed out in the intro, the effective date of all of these regulations is May of 2018. So we need to be thinking about how we're impacted by GDPR, whether and to what extent we need to comply, and start developing compliance programs now, because if we wait until spring of next year, we're going to be too late. So if a service provider transfers data outside of the EU, then the MSP must be compliant with the GDPR's guidelines. If you remember, one of the preamble points of GDPR was that movement of data was not to be restricted. Well, the compromise for that was all data movement has to be subject to the GDPR. So previously, there were some laws that limited the ability to move data from jurisdiction to jurisdiction, and there are a number of problems with such a scheme. And so what we're seeing here, the combination of the limitation on restrictions and the requirement that all transfers be subject to GDPR, is kind of a new approach in that regard, and I think a good approach. So this is really the meat of what the rights are that are being created by GDPR. So what is it? They say in the preamble it's a fundamental right. Data protection is a fundamental right, that if you're an EU citizen, that you have the right to have your data protected. And this talks about what is it that means in particular. What is the substance of those rights? So think about in the U.S. under our Constitution, we talk in terms of certain inalienable rights, and then we have the Bill of Rights that identify what what we mean by that. And similarly here, we've got a proposition that says that data protection is fundamental, but then we go into specific details of how that is to be executed. And there's a significant difference here in GDPR than what we see in other regulations, particularly even those U.S. federal regulations that have some overlap. None of them have all of these rights articulated from a data subject's perspective. One of the rights is that the data subject shall have the right to have inaccurate data concerning him or her corrected. So I can't tell you how many times people have struggled with hosting companies, social media companies, cloud providers, and others that are hosting inaccurate information about them. They write a letter, they try to get it changed. If there's not a Digital Millennium Copyright Act problem, then frequently, historically, particularly in the U.S., there has been limited legislative right of a subject to have someone that's housing their data and displaying it to have it corrected. So Article 16 requires or articulates the right to rectification, which means if your data is being presented, displayed inaccurately, then you have a legal right under GDPR without undue delay to require the controller or processor of that data to rectify that inaccuracy. The most controversial new right, the one that's got IT organizations in a frenzy, is the right to be forgotten. And what does that mean? It means that all of your personal data must be erased everywhere without undue delay. Retention is not required. Data is no longer needed. Consent is withdrawn. This is going to have a very significant impact on how controllers and processors do business. Think about data backups and think about all the places that customer data resides within an organization, in indexes, in business intelligence databases, in CRM databases, and backups of various systems. So one of the challenges is, how will we execute post-May of 18 when one of our customers or one of our customers' customers exercises the right to be forgotten, and we get on the without undue delay clock to make that happen? That is going to be a difficult challenge, because most of my clients today don't have the technical capability to execute on a requirement like this. And I would suggest that many large businesses will struggle with this requirement. I think this is one that is unique to GDPR and has the most disruptive potential impact in terms of compliance. We have the right to restriction of processing. Data subject has the right to obtain from the controller restriction of processing where accuracy of data is contested, where processing is unlawful, where the controller no longer needs the personal data for purposes of processing, and where the data subject has objected to the processing pursuant to Article 21(1), the right to object. So what you're seeing here is some very powerful legislation that's going to put a lot of leverage in the hands of data subjects and put a lot of burden in the hands of controllers and processors who are, from an IT perspective, storing, processing, or monitoring EU subject data. The right to data portability. So this is primarily targeted at cloud service providers, but individuals have the right to transmit the data to another service provider when it's technically feasible. So this is similar to the mobile phone portability rights that we saw emerging in the U.S. from a telecom perspective. This is data portability. I want to be able to move my data from provider to provider. Right to object, we already talked about. And again, a lot of rules that give power to data subjects. So privacy by design is a concept that is essentially requires policies and safeguards to protect personal data. I think in this area you see a lot of overlap. In fact, you see that implementation of appropriate technical, physical, and administrative measures, that comes directly out of GDPR, out of GLBA. So there's a high level of overlap here between GDPR and GLBA. The whole life cycle and process development must be. The other thing here is you have to be transparent in your dealings with individuals. So the development of privacy policies, if you've got privacy policies that articulate what you're doing with data and you're subject to GDPR, you need to look at your privacy policies and make sure that you're complying with this transparency requirement. You don't want to wind up like Microsoft and others who have allowed their marketing people to write their privacy policies only later to wind up with FTC or other claims associated with the accuracy of those policies. So if you're regulated by GDPR, this is a good time to make sure that you're being transparent about your dealings with individual data in your policies. Data controllers will no longer need to submit routine notifications to the Data Protection Authority, so there's a regulatory realignment here. And the concept of privacy by default simply means that the strictest privacy settings automatically apply once a customer acquires a new product or service. In other words, the default privacy option is the strictest. In other words, there's no manual change to privacy settings should be required on the part of the user. The user must specifically opt out of the strongest privacy settings, and this is something similar to what we see in the U.S. in regulations like GLBA and HIPAA, where we have a privacy and choice model. The concept of consent under GDPR. Consent must be given by clear affirmative action in order to establish a freely given, specific, informed, and unambiguous agreement to the processing. The following are a few points to remember when you're thinking about whether or not you obtained the necessary consent to process data under the GDPR. It's not freely given. It's a clear imbalance between the data subject and the controller, particularly when the controller is a public authority. Controller cannot make service conditional upon consent unless processing is necessary for service. Specific to data collection purpose, new consent for additional processing is incompatible with the original purpose. It's an affirmative opt-in. It's not an opt-out. Can be shown by a statement or conduct which clearly indicates acceptance. So these are, contract formation concepts around consent. Consent has to be the equivalent of the contract formation. It has to be freely given. It has to be informed. It has to be unambiguous. And there are rules regarding parental consent. Each state can determine age of consent, 13 or above. For most, it's been 16. And there's also special categories of data that require explicit consent. In general, blanket consent will not be sufficient for the processing of personal data revealing racial or ethnic origin, political opinions, religious or philosophical beliefs, or trade union membership, and the processing of genetic data, biometric data for the purposes of uniquely identifying a person, data concerning health, or data concerning natural person's sex life or sexual orientation shall be prohibited unless consent is given. So, wow. Facebook has got a hell of a problem because look at all of these things, political opinions, religious and philosophical beliefs, it's going to be very hard to wade through the consent concepts in GDPR, particularly for those that have consumer-generated content, for those that are in hosting businesses. It's going to be very important that the explicit consent rules in Article 9 are complied with. I see a potential for some serious problems in the obtaining of the appropriate consents under this regulation. So there's a regulatory regime for enforcement, a supervisory authority, a data protection authority, and the European Data Protection Board, the old working party, will become the Data Protection Board with legal personality and extensive powers to determine disputes between national supervisory authorities, to give advice and guidance, to approve EU-wide codes and certification. So got a whole new regulatory regime here, bringing in a great deal of uncertainty about what the future holds. And so we just need to keep our eye on what develops as it develops, and deal with the regulations as we can now, to get into the best position to be in compliance while monitoring the evolution as things develop. So why should you care? The fines are pretty significant on both controllers and processors. There are two different levels. 2% of an organization's prior worldwide turnover, or up to 20 million euros, or 4% of an organization's prior worldwide turnover. So we've got some pretty significant penalties here from a financial perspective, and we certainly want to make sure that we're not running into these types of problems, because financially could be significant. In addition, there's a private right of action, much different than GLBA and HIPAA and many of the privacy regulations in the United States, which have exclusive enforcement by state or federal agencies. Now you've got a private right of action, which means individuals who are affected could bring individual claims, or more likely class action or group action type claims. And those actions against data processes for breaches of the applicable sections of GDPR, and the burden of proof lies with the data controller or processor. So now you've got a private right of action where an individual could bring a litigation against a processor or controller, and the burden of proof lies with the defendant. This is a very anti-American approach to legislation. I can't think of any legislation in the U.S. that has a regulatory regime with a private right of action where the burden of proof is on the defendant. But Article 79 and Article 82 of the GDPR create exactly such a regime. And what I think for my clients, one thing that I would suggest is a look at your cyber liability coverage to make sure that these private rights of action will be covered by your policy, and that your insurance carrier will defend you and hold you harmless from any claims that arise under this section. And I think it's important to make sure that as the threat landscape for regulatory compliance and security and privacy emerges, which this is a huge example of that we're working with our risk management teams or outside insurance advisors to make sure that our coverage is up to the challenge of the changes that we're experiencing. And this is one where I could see a lot of litigation arising on the part of consumers and consumer groups using this private right of action to bring claims. And I think it's going to be very important for companies to ensure that from a risk management perspective, their insurance coverage has taken this into account. So moving into the more practical aspects of GDPR and how one would go about sort of wading through this landscape. And we've developed this little roadmap for you to follow to determine if your business is required to be compliant with GDPR and what steps need to be taken to prepare. And if you look to the right in your console for the GoToWebinar, you'll see that there are handouts here, and one of the handouts is the roadmap and decision tree, and that's the document that is being displayed here. And so feel free to download those at your convenience, but I plan to walk you through them now. So the first issue is a question of territorial scope. I mean, does the regulation reach to your business? And question one is your business or any part of your business located in the EU? If the question is yes, then you'll jump to question 4, which for those of you who want to get a preview of that, it contains the definition of personal data. So if you're in the EU and you're processing personal data is in your possession, then you're subject to the regulation. I think that's fairly straightforward. So if you're a global corporation, you've got EU employees, you're probably subject to the regulation. If you've got customers in the EU, you're offering goods or services in the EU, or consumers in the EU are availing themselves of your services that may be offered outside of the EU. If the answer to that is yes, then it's a question of whether or not personal data is in your possession, and if it is, then you're subject to GDPR. If the answer to number 2 is no, that means you are neither located in the EU and you're not offering goods and services in the EU. Then you have to ask your question, are you monitoring the behavior of EU subjects as far as their behavior takes place in the EU? So if you're doing, consumer analytics, if you've got cookies, if you're looking at searching behaviors, if you have GPS technologies, anything that might be considered monitoring the behavior of EU data subjects, then the answer is yes to that question. Then you are subject to GDPR if personal data is in your protection. And the answer is no. If the answer is no, then you go to question 4. So question 4 is really the key. What is the data? Types of personal data in possession. Is the personal data you have in your possession any of the following? Any information relating to an identified or an identifiable natural person. So personally identifiable information, what we call in the US PII, is personal data. An identifiable natural person is one who can be identified directly or indirectly, in particular by reference to an identifier such as a name, an ID number, location data, an online identifier, or to one or more factors specific to the physical, physiological, genetic, mental, economic, cultural, or social identity of that person. Wow. This is a very broad description of personal data. If you think about U.S. privacy regulations, we're typically talking about very specific data elements like name and account number, name and social security number, name and other personally identifiable information, but certainly not anything as broad as an online name. This is the broadest definition of personal data that I have seen in any privacy regulation, and certainly broader than any in the U.S. You see the note here that if the location data, online identifiers, and generic data meet the definition, it may result in additional compliance obligations. Cookies in particular are online identifiers and things that you'll need to be concerned about. And think, this is a regulation that is specifically designed to target global cloud service providers and global social media companies. And that's why you see this definition being so broad. So if you have any personal data in your possession of EU subjects under number 4, which, it's very broad, as you can see, then you go to question number 5. If the answer is yes, you look and you say, if you do not have personal data of an EU data subject in your possession, then you are not subject to GDPR. If you are not, 1, located in the EU, 2, not offering goods or services in the EU, and 3, you are not monitoring behavior of EU subjects, then you are not subject to GDPR. So we're getting down to some very concrete sort of yes and no outcomes here. Are you processing personal data of EU data subjects? This is one that has given me and my clients a great deal of fit, because if you're a service provider offering managed services or hosting services, you're not a controller in the sense that it's not your end user customer data that's in question, but rather your hosting or processing data because you're a service provider to a controller that has EU data subjects in their database. And so the question becomes, is the particular service that's being offered or contemplated in connection with a transaction, does it constitute processing under GDPR? And this is a very tricky question. Processing means any operation or set of operations which is performed on personal data or on sets of personal data, whether or not by automated means, such as, so this is including but not limited to, collection, recording, organization, structuring, storage, adaptation or alteration, retrieval, consultation, use, disclosure by transmission, dissemination or otherwise making available, alignment or combination, restriction, erasure, or destruction. So again, very broad question, a very broad definition of processing, but one that lacks, in my opinion, specific specificity to determine whether or not a particular IT service offering constitutes processing. If I'm a managed service provider in the US and I'm offering desktop support services for an EU controller, does that make me a processor? And so I started asking all of these questions, and I decided that we needed a separate decision tree for what constitutes processing at a more detailed level. And so we developed this general protection roadmap for processors. And what you can see is we've got very common IT services broken down into sections. So we've got, if it's server services, if it's network infrastructure services, if it's security services, application services, workstation and device services, and other general services listed here. And we've provided sort of a checkbox approach. This is just a sample checkbox here, so this don't read anything into the checks and X's, but this is a roadmap that we can follow and we can start looking at very specific offerings. And so this would be good to use if you're in the IT procurement operation involved in hiring processors that will be subject to GDPR, and you're evaluating whether or not a particular service offering that you're planning to buy is subject to GDPR, such that you'll need special contract language in your agreement with the provider, or whether or not you can safely conclude during your due diligence process that they're not a processor for purposes of GDPR. And this type of checklist would be something that would be valuable to put with your due diligence, because you have an obligation to do due diligence in connection with choosing processors, and this type of document can help with that. Similarly, if you're an IT service provider, you could use this document to help guide your discussions around whether or not and to what extent your services constitute processing under GDPR. So that gets us through to question 6. If you're not processing personal data of an EU data subject, then you're not regulated under GDPR. However, if you use personal data of an EU data subject in any way, then you still may be regulated under GDPR, because processing is defined as use. So you need to be careful to make sure that you're not doing anything within your organization to use EU data subject personal data, even if you're not processing in the traditional IT sense of storing or hosting or transmitting. So that kind of covers the what is a processor. The other significant entity type under GDPR is the controller. And in the context of IT procurement, this would be the customer and not the service provider. So that the controller is a natural or legal person, public authority, agency, or other body which alone or jointly with others determines the purposes and means of the processing of personal data. Where the purposes and means of processing are determined by a union or member state law, the controller or the specific criteria for its nomination may be provided by union or member state. Processor means a natural or legal person which processes personal data on behalf of the controller. So again, the controller is the one who is responsible for the data, and the processor is the one that processes data on behalf of a controller. So that would be the service provider, the hosting company, the cloud company, the managed services company. Those would all be potentially processors under this regime. The subprocessor is another entity type which processes personal data on behalf of a processor with the controller's consent. So this would be a subcontractor of a vendor. So the vendor has an agreement with the controller to provide IT services which constitute processing under GDPR. With the consent of that controller, that processor may have the right to subcontract a portion of those services, and if they do so, the entity to which they subcontract shall be defined as a subprocessor under GDPR. And so here's how you determine if you're a processor. If you're not processing personal data of an EU subject, then you're not regulated under GDPR. But if you are a controller, 7, 8, or 9, then you need to go. If the answer to question 6 is yes, then you need to continue down the roadmap to question numbers 7 and 8. So if you are a processor, what does that mean from a compliance perspective? And this section 8 articulates what you must do to meet the guidelines. Include contract language to be in compliance with processing or controlling. So we have developed, similar to what we've done for our IT services clients under HIPAA and GLBA, we have developed a GDPR addendum that would bolt onto a master agreement, and that addendum would be in compliance with Article 28.6 and Article 46.3a of the GDPR. And what the GDPR is saying is if you're a processor, you need to have or you're hiring a processor, both controllers and processors need to have specific contracts that cover specific items that are articulated in the agreement. And this is something that we're doing now with our clients, both from a procurement perspective for those that are controllers that are entering into contracts with service providers, as well as our service provider clients. We're making sure that to the extent that the contracts that are entered into today will still be in effect in May of 2018, that we're making sure that to the extent possible, we're complying with these contract provisions, these contract requirements. We're trying to make sure that all of the contracts that are going to be entered into now and going forward that will continue past the effective date will have the appropriate contract language included. And if you're interested in getting an addendum for your master services agreement, please feel free to contact us. That's a service that we are offering to our clients, similar to the addenda that we've created for other regulatory regimes. Your security policies have to be reviewed. You need a written information security policy to ensure appropriate technical, administrative, and physical safeguards. If you're doing anything with banking or GLBA, you already have this in place. This is a regulation that is verbatim to the safeguards rules of GLBA. The privacy policy, you need to review and revise your privacy policies to ensure they are written in clear and plain language and fully disclose your data processing and collection processing practices. As I said earlier, if you're governed by GLBA, now is the time to take a fresh look at your privacy policies and make sure that they're written in plain language and comply with these requirements. Look at your consent process and make sure that you are complying with the regulation that requires informed and unambiguous opt-in consent. The last thing is to appoint a data privacy officer or considering hiring one. A controller or a processor may need to appoint or hire a DPO to serve on its behalf if local law requires it or if data processing activities involve systematic monitoring or processing of sensitive personal data on a large scale. Hiring an attorney with expertise as a DPO creates an attorney-client privilege where the exchange of information is considered privileged and confidential. We anticipate that there will be a large number of clients that are looking to hire our firm to serve as a data protection officer. This would be customers that don't have a significant enough operation in the EU to have a full-time DPO, but that still have a legal requirement to have a DPO in place. And given the way the regulations are written for the requirements of a DPO being independent, I think the regulations were written with an emphasis on the use of law firms to serve in a virtual or part-time DPO capacity. And we are offering those services to our clients. If that you find that you have a need or are considering whether you need a DPO and are interested in learning about Scott & Scott's DPO services, this is a new service that we're offering for our clients, and we expect that a number of our service provider clients will need DPO help, and many of our mid-market or large clients that have limited operations in the EU will consider using us as a DPO instead of hiring a full-time person. In addition, you must have confidentiality agreements in place with employees. This is a new regulation, not something I've seen anywhere else. And we talked a little bit before about insurance. You need to, if you're subject to GDPR, you've got a whole host of new risks and risk management challenges, and you need to involve your risk management organization, or if you work with an outside agent, that an insurance review in light of GDPR, particularly in connection with your cyber liability coverage, whether it's an E&O coverage or a first-party cyber coverage, needs to be looked at in detail. So what is it that you can start doing today if you're processing? Start a data inventory. What does that mean? Look at the data that you're housing. In many ways, this regulation is moving us in a direction where data content, privacy content, individual records are going to be tracked in the way that we currently track assets. We're going to need to be able to inventory our data. We're going to need to be able to categorize our data and determine to what extent it's subject to the regulations or not. And now is the time to start that data inventory. And Articles 29, Articles 30 and 33 discuss the data inventory and how you need to go about that. You need to put processes in place for data protection impact assessment. For those of you who are regulated or familiar with regulations under HIPAA or GLBA, this is the risk assessment piece of those regimes. You have to have an ongoing risk assessment process to be in compliance with any of these major privacy regulations, and GDPR is no exception. I don't think it adds a whole lot, but if you have been in a non-regulated mode because you're neither healthcare nor financial services, but you process EU data subjects, this could be a big change for you. This continuous risk assessment obligation is significant, as well as the due diligence obligation. They're very significant. So what do you need to be thinking about your data, and how do you go about looking at records of your data? What kind of detailed records do you need? This is very new. I'm not aware of any legislation in the U.S. that requires detailed records of personal data processing activities. And so, coming up with a compliance regime to ensure that the records that you're keeping are appropriate and implementing those processes and procedures around maintaining those records, I think is going to be a significant challenge for many processors. We've got a number of detailed requirements around data collection, such as limited storage and data minimization, accountability for compliance. The controller shall be responsible for and be able to demonstrate compliance. So this is important. We've got the burden of proof in a private right of action, and we've got the burden of proof to demonstrate compliance from a regulatory perspective. So very, very difficult. Some further rules here, detailed rules about the lawfulness of processing and the conditions for consent. I'm going to go over those quickly here. One of the things that you see here is proof of consent. Shall be able to demonstrate that the data subject has consented to the processing of his and her personal data. So these sort of generic, if you use this, you consent kind of models, the kind of, we gave you a piece of paper and you didn't opt out approach is not going to work. We're going to have proof. We're going to have to be able to demonstrate that the data subject has consented. This is going to potentially create a number of new processes and data collection activities, and could require changes to business processes, client onboarding, and a number of other different tasks. Further details here on this slide about consent and children's consent. You can see that this is a very detailed regulatory scheme with lots of potential pitfalls, and you see that we've annotated each of the sections with the applicable provisions. So if this is any of these areas are something that potentially affects your operation, you can easily dig in and find the underlying text. One of the things that I think is interesting from a service provider's perspective is where a processor is in breach of the GDPR, determines the purposes and means and processing activity, that processor is treated as a controller in respect of the processing activity. In other words, you've got some limited protections as a processor versus a controller, but if as a processor you breach or are found in violation, then you'll be treated as a controller for purposes of regulatory and other aspects. So this is a significant provision that puts processors at greater risk, and it's something you really need to be thinking about. We talked about contractual requirements between processors and controllers. This Article 28(3)b and Article 29 require that the contract between the controller and the processor must require the processor to ensure that all persons authorized to process the personal data are under an appropriate obligation of confidentiality. So as a processor, if you haven't been in the business of obtaining confidentiality agreements from all of your employees, all of your consultants, all of your contractors that have access to your data, if you're governed by GDPR, you're going to need to change that. You're going to need to have confidentiality agreements for all of them. There's a data breach notification rule at Article 33. If a processor is aware of any data breach, the controller must notify the controller without undue delay. Why is that? Because the controller has the obligation to give the notice of breach. The processor has the obligation to notify the controller. Otherwise, a controller could outsource to a processor. The processor could discover a breach, never report it to the controller, and then the affected persons would never be notified. Data subjects can bring claims directly against processors. However, a processor is liable for damages caused by its processing activities only where it has not complied with the obligations under the GDPR specifically directed to processes or acted outside or contrary to lawful instructions of the controller. This language, I think, is critical to what needs to be included in a processor's agreement with a controller. Why? Because there's a private right of action by the individual person. The processor can be sued, and the processor's defense is going to be A, I complied with GDPR, and B, I conformed to the instructions of the controller. If you acted outside of the instructions of the controller, you're not in any kind of a safe haven by virtue of being in compliance with GDPR. And therefore, I expect a lot of litigation by individuals against both controllers and processors, where the issue will be whether or not the processor is partially responsible for a privacy issue that it didn't legally undertake, was not the result of its negligence, and where it didn't, and the issue will be whether or not the processor's activity was outside the instructions or contrary to the lawful instructions of the controller. So if you're a controller and you want to make sure that your processor is responsible, you draft your instructions in your addendum, your GDPR addendum, to very clearly track any kind of issue that would subject you to a financial exposure that could be the responsibility of the processor. If you're a processor, you want to very narrowly construe the circumstances under which you could be held liable for a claim by an individual. And the indemnity provisions between the processor and the controller are going to become, I think, increasingly negotiated as a result of this provision, because now we've got an increased risk. We've got a private right of action where someone with whom you have no contractual privity, you're a processor, you have no contractual privity with the end user, but now by virtue of this regulation, they have a private right of action against you. And the processor must assist the controller with all of these new rights that are going to be very expensive to comply with. So it doesn't say who has to pay for the controller's assistance. And I would suggest that in contracts, you want to make it very clear whether or not, if you're contracting a service provider, whether or not and to what extent their cooperation and assistance with, for example, the right to be forgotten would be something that they would be paid extra for or not. So these are very important issues, thorny issues that go to contracting when we're dealing with regulated data under GDPR. Finally, there is a certification process. If you want to get your organization certified as in compliance with GDPR, there are certain safe havens that you can get from that process. And if you're interested in that, Article 42 will cover that. For those of you in the managed services business, the Unified Standard for Cloud and Managed Services will have effective next year, we'll have a GDPR module. We're actually working on that now as part of that compliance standard, certification standard for managed services and cloud. And so if you're in the managed services and cloud business, you may want to think about getting the UCS as opposed to an Article 42 certification. If you're an end user with significant EU operations, you might want to think about getting your organization certified. And if you're a sub-processor, that would be someone, a processor that is outsourcing to a sub. You must follow the above guidelines for processors, but also must enter into contractual relationship with the processor with the consent of the controller to process the data. So in other words, you can't just contract with it can't be between service providers only. The subcontractor service provider has to have a written consent of the controller. That would be a new requirement and fairly atypical in IT services. It's fairly atypical that the end user customer has to consent to the contractual relationship, although sometimes it happens. In this context, it's required. So you need to make sure your contracts, both procurement and service provider contracts, cover this requirement. So what kind of advice are we giving to our clients? May 25th is the launch date. A lot of changes coming. Time is much shorter than it seems. If you haven't gotten started yet, it may be time for you to seek legal counsel around these issues. As you can see, they're pretty thorny and involved, and it will be May before you know it. And if you are subject to the regulation, you need some runway to develop some policies and procedures around compliance. This slide here gives you a recap. It talks about contractual and transactional compliance, which we talked about quite a bit, which would be very helpful for you in connection with working on contracts that may implicate GDPR. And we also talked about things here that you need to do if you're a processor. If you have questions, you can feel free to contact us. My contact information is on this slide. You have my email address here as well as our website and my direct dial phone number. If you're interested in talking about GDPR compliance, whether you're a service provider or involved in IT procurement, we'd love to talk to you about it. It's a new and emerging area for us. We're very excited about the possibilities and frankly concerned about some of the more troubling aspects. But we plan to work hand in hand with our clients to make sure that they're ready when it comes time in May. Thank you very much.